So the parties reached any arrangement on the application number of the 22nd. Batuta?
Yeah, Kiragwa Dutta, my lord. For the petitioners and for the respondents, I don't know whether you forgot Mr. Mbeere. We have in principle agreed to have the matter taken out today, subject to the convenience of the court, so that we can use the materials that are now available, because we have, from our deliberations, it's clear that the application will narrow down significantly, so that we only come to address you on the one or two requests or prayers. We've been informed that the court diary is very tight.
Yes, it is.
Because we had suggested that cumulatively, since we did not more than 1 hour, because myself at 10 minutes, maybe maximum 1 hour, subject to the convenience of the court. We had proposed Wednesday afternoon, maybe from 3 to 4 or 2 to 3. And if that's is not convenient, the other week, say on Monday or Tuesday, only 1 hour.
What is on Wednesday, Mr. Francis?
They have to or morning at 8 a.m.
I think that would probably be better for me. Because I think the way I've been looking at the calendar, the diary looks very heavy.
Yeah.
Unless we can, next week is actually some supervisory.
It's a civil week.
A civil week, that's usually a bad week.
Maybe the other week.
On a criminal week would be better.
Yeah.
Early morning at 8 o'clock or 8:30?
Yes.
Yeah? 8 o'clock or 8:30?
You can do 8:30.
8:30.
Anything from Monday to Thursday. The week of 23rd.
We can take the Tuesday, the 24th of February.
24th February. I'm sorry, can you hear me? Is that any better? Okay, did you hear Mr. Waduta? Did you hear Mr. Waduta speaking? Basically, he's saying that following their discussions, an application dated 22nd of December 2026, sorry, 25, can be deferred to another day, probably 24th of February 2026 at 8:30 a.m. That's what Mr. Waduta has proposed, and I was just about to ask IEBC what their position is. Angela? Yes. And then we have Mr. Gashuba or Kamotho.
Well, if it pleases the court, we could also have the application considered at the same time that we come for the other matter that we have just had, the other application that we had made.
The one that has been argued this morning.
The one that was argued. So the same day that we come for the ruling, then if it is available for the court, we could come on the same occasion.
It may not be available because you're giving me, basically, you're giving me 12 days.
Right.
Not even 12.
Subject to the availability within the court's diary.
That ruling I'll give you definitely before the 9th.
So we are ready to proceed on 24th.
Okay. So that's 8:30 a.m. on 24th. What's our diary?
Yes, madam.
8:30.
Yes, on the 24th.
No children's matters. Any children's adoption matters?
No, we don't have any adoption matter.
I'll assume each party will take 15 minutes, so I've said for 45 minutes.
Yeah, that's okay with us.
Okay.
My lord, before, probably you give the direction, maybe we could also decide whether we'll do the same hybrid, virtually or physically. Directions.
It can be hybrid if you want. But is that okay?
We can consider hybrid.
Hybrid?
I believe it will suit all parties.
I think we said the main hearing of the witness is the one that has to be face to face.
Very well, my lord.
I don't know whether, my lord, the parties will have to be present on that day, or you can just.
No, the parties don't have to be present. It's an application. It's one application. Even today, they didn't actually have to be present.
Oh, very well.
Yeah.
Yeah.
Their counsel are here. I think the main decisions were made during the pre-trial.
Sure.
So there are no big decisions to be made now.
Very well.
Yeah, but I'm sure they will want to come for the hearing if it proceeds.
Yeah.
Yeah.
Thank you.
Okay, so we will hear the application on 24th. The application of 22nd December 25 will be heard on 24th February 2026 at 8:30 a.m. for 45 minutes.
Most obliged.
We can then, is there anything else for this, for petition number 2? I don't think so. I think we can go to the petition number 1. Oh, we haven't given a ruling date on petition 2. The ruling date for the application. If you give me about 20 days, Francis, where does that take us to? 20, 25-ish?
To take us to the week of the petition, that is on the 12th of March.
20 days.
5th, around 5th.
Next week. Next week, 10 days, 26, and then 5 days, 26, 10 days, 15 days, then 23, we have to do.
So why don't we say, can we do it on the 2nd or 3rd of March?
Can do it on the 2nd of March.
The ruling. Yeah, sure.
The ruling, it can be online.
Or it can be sent on email or uploaded. on-
Parties are agreeable, we can just upload it.
As you okay.
You want it uploaded?
We would have no issue.
Okay. Ruling on, which date was that? Mongela? Can the ruling be uploaded? What date have you given us?
The 2nd of March.
2nd March. By consent, ruling to be uploaded on CTS. Okay. Actually, there's one other thing that I think we should do before we pen off on this petition number 2. I think we should assume that the hearing is going to proceed. We can take time allocation. Remember we talked about the time bank some time back? Can we do that now? We know who our witnesses are, so we can probably do a time bank. Let's start with the petitioner. How many witnesses?
Yeah. Currently, my lord, we have 18
witnesses.
with a rider that we may drop some as we condense the matter.
Okay. And respondents 1 to 3. Respondents 1 to 3, Mongela. How many witnesses? Is Mongela there? Has he dropped out?
Yes, you talk.
Mongela, we are trying to do a time frame for the hearing, to allocate time for the hearing from 9th of March. How many witnesses do you have for your case? All right, let's go for respondents 1 to 3. Respondent 4.
On our part, my lord, we have one witness.
One witness, the respondent himself.
Correct, my lord.
Okay. So the way, sorry? Sorry, Mongela? Uh-huh. Uh-huh. Yes. How did you serve those? How did you come up with witnesses?
Last time you had granted us leave to file further witness statements or affidavits upon being served by Mr. Kamotho's affidavits and Mr. Mongela's affidavit. So they served after we were before you. So we were just doing a rejoinder pursuant to the leave that was granted.
So how many did you add?
We added 3.
So, Mr. Mongela, what did you want to do? How many? Mr. Kamodo, you're not affected in this.
Yeah, for us, I will not object to Mr. Mwongera's proposal, but we could put a rider that if need be, within the same time frame, we can also file any further witness affidavits.
The problem I'm beginning to see is that we'll keep doing this. Your case is made up already by one witness.
That is the position.
Yeah.
But now that there is that window that is available for 7 days, we could, in the event that there is need for further input, then within the same time frame, and that will not be prejudicial to any of the parties.
Waduta? Somebody is speaking?
Yeah, Kiragu Waduta. For Mr. Mwongela, he can have maybe more limited time because we again had time to respond in the hearing that is fast approaching. So if, while ordinarily he will not have that right to respond because we were actually responding to his affidavit, then he can just bring the evidence. Then us, we just come and file 7 days thereafter, just to close the issue of pleadings. But this one, my lord, will be very gracious to allow him because already he exhausted his opportunity. But if he's willing, it's okay. Let's not shut him out.
Okay, what I've done is granting the first to third respondents leave to file and serve up to 3 witness statements, but with a reduced time of 5 days from today's date. The petitioner and the 4th respondent are granted leave to file no more than 3 witness statements within 3 days of being served. The pleadings close thereafter.
Most obliged.
In 8 days, we don't have any more papers coming in. Okay, so assuming there's an additional 3 witness statements, petitioner, you now have 21.
Yes.
Assuming 3 additional. Respondents, you now have, I think, 15. First to third respondents. Mwongela, yeah, that would be 15. And respondent 4 would now have 4.
Correct, my lord.
We are talking about the maximum. When the time comes, we'll look at the statements and I'll make proposals about who should be dropped, which witnesses should be dropped, especially if there are very obvious repetitions.
Yeah.
So assuming you have 21 witnesses petitioner, I need to know how much time you will be bringing their witness statements, you will be presenting them.
Yes.
Basically for cross-examination.
Yes, ma'am.
So you look at the other side.
Yes.
The respondents 1, 2, 3 has 15 witnesses.
Yes.
And 4 has 4 witnesses.
Yes.
That's 19 witnesses. Let's say 20 witnesses.
Yes.
You are going to cross-examine them.
Yes.
How much time would you need? Because that's how you're making your case.
Yeah. The main witnesses for the fourth respondent, I think I would only take maybe 20 minutes. 30 minutes. And then for the others, sorry, I'm being advised that we can work for now with 30 minutes per witness.
Times 30, 600 minutes.
Some of them are very short, we may take much less, but for some we may take more, so we balance.
That would be 10 hours.
Yes,
That is literally 2 days. Because our days, you remember, are divided into 5 hours?
yes,
According to that chart we had, the sheet.
yeah.
So you're doing 2 days of cross-examination.
Yes, my lord, as I said, it will change significantly because I've looked at some of the witness statements.
You see, you have taken 30 minutes for each witness, which is really a long time.
That's a lot.
It's a lot of time. There are some witnesses you'll be able to finish within 5 minutes.
Sure, indeed.
Then there are some who will take 25.
Yes.
Maybe a big witness
Yeah,
may take, IBC may take you an hour,
much more.
isn't it?
Yeah.
So if we are saying you get your 10 hours, that's the 10 hours you need for your case.
Yeah,
So you need 2 days.
yeah, 2 days. It may change. Maybe we can take how others will take, then we can balance out.
All right. Let's see, respondents 1, 2, 3. Respondents 1, 2, 3. You also do 2 days. And you have no work.
Well, actually, our work is being led by the petitioner.
Yes. You'll be,
So we would, and now that we are the main target by the petitioner, then we'll require some adequate time, but not exceeding 2 days.
okay. We say 2 days, that would be 2, 4, 6. 2 days each. So at least we'll be able to fit in within the time that we've already set aside from 9th of March. So this is how it will look. If it's 2 days, 10 hours each. That gives us 600 minutes. $600 each. So that is your time bank. Because you have a bit of extra time, let's even say 650 minutes.
Yes.
Because there's re-examination we haven't taken into account. Let's say 650 minutes for each party, which is now your time bank. you will draw down on your 650 minutes whenever you're on your feet. Is that okay?
That's
Whether you are cross-examining, whether you are arguing something, whether you are stopping counsel from speaking because you want to interject, whatever it is, when you're on your feet, your 650 minutes will be going. All right? Because you're making your case.
yeah.
Is that good, Mr. Nakamoto?
I am totally satisfied. That's a good approach.
It's a good approach. So we've agreed at 650 minutes each party, and it's being drawn down from the date when we begin on the 9th. And we have that program. Do you still have these papers? You threw them away.
Yes, we do.
Just give it to them. You can just fit in your time. It's 650 minutes for each party. The rest of the time will be taken up by slack time, rulings, Benny. Are we okay with that?
We okay.
Thank you. We can now leave petition number 2 and go to the ruling in petition number 1. Yes? Yes, we are roped. We would be roped from the 9th until the petition comes to a close. Now, don't forget one thing we have not taken into account is if there is scrutiny and recount. That will be an exercise that is separate. It will be done by the DR. So that time frame is not incorporated in this. This is just for your arguments and for your witnesses.
Yeah.
So what will happen during scrutiny and recount, if it occurs, is that once it is done, you will be making submissions on the report by the DR. Okay, so that's not part of this time. We'll allocate separate time for that.
Thank you, my lord.
Shuba, are we okay now? So we can place file number 2 aside, go to file number 1.
Election petition number E001 of 2025, Julieta Karigi Kipumbu and Patrick Getonga Geshoni versus Leo Wamuthende Jero, IEBC, and the returning officer, Mbeere North Constituency.
Do you want me to read the whole thing, or should we go to the conclusions and disposition?
Just the disposition, my lord.
Conclusion and disposition. Just by way of background, we were dealing with 2 applications dated 18th December 25 and 29th December 25. I am aware that there are other applications, one for with regard to jurisdiction, 27th December 2025, which was not under certificate, and therefore no directions have been given on that one. And there the other application for preservation, which has not been dealt with. So it's just the first and second application. I'm calling them the first and second applications, the ones on which submissions are filed by the parties. The first and second applications, this is the conclusion and disposition, are allowed, succeed and are allowed with the result of the petition, cannot proceed any further. Accordingly, the petition by Julieta Kariki Katumbo and Patrick Gitonga Gishoni, dated 1st December 2025, against the election of Leonard Wamudende Njeru, namely petition number 1 of 2025, is hereby dismissed for failure to comply with the mandatory requirement to deposit 500,000 shillings as a security deposit into court within 10 days after filing the petition. With this finding, all other pending applications in the petition hereby lapse and become odious. They are hereby marked as such since their relevance depended on the continuance of the petition. Party and party costs herein are awarded to the respondents, capped to a total maximum amount of Kenya shillings 800,000, and such costs shall be subject to taxation by the Deputy Registrar. Orders accordingly.
We are most obliged.
Most obliged, madam.
With regard to costs, I just want to make a little comment off the cuff. I think when you look at the case law, the cases related to the elections of 2013 and 2017, the amounts that were awarded were very high. And the Supreme Court came and gave guidelines in 2018 concerning costs and how they should be dealt with. And on the basis of that Supreme Court case, was Cyprian Awiti, I referred to it in the ruling, that it is on the basis of that in 2022 you find that the costs awarded in petitions dropped drastically, and that is why I've adopted this kind of an approach. That's the ruling. I have, so that we are not misquoted by our colleagues here. There is a press or media summary.
Mr. Chair.
And you can give a copy to the council so they can see that we have not misled the media either. This one is for my file. Oh, there's a next. Maybe another council can get another one.
My lord,
Yes.
just to confirm that the full decision will be made available.
Yes, it is ready. It will be uploaded today, in the afternoon probably. Yeah, it's right there. I think that is it. Is there anything else that we need to deal with?
From us,
Sawatuta?
no, I think we are okay.
Mungela?
24th.
Mungela? And Shubak Kamoga?
We also,
All right. Thank you very much. Bring this to me. So we have a good afternoon all. Thank you very much.
By our friends here.
Yes.